Good morning, ladies and gentlemen. Thank you for joining today's AMCHAM webinar. I am Michael Claiborne, Head of Government and Corporate Affairs at AMCHAM Korea. The topic of today's event is the Serious Accidents Punishment Act. This is a valuable opportunity to learn more about this new legislation affecting the business community in Korea. The three speakers from Kim and Chang, Mr. Kyson Baek, Mr. J.J. Kim, and Mr. Sungmin Won, will share their insights on the recently passed legislation and ways for companies to mitigate risks. We sincerely thank our speakers for sharing their expertise on this very important subject. There will be an opportunity for Q&A towards the end of the event. If you would like to ask any questions, please submit your question in writing at any time by clicking the Q&A button at the bottom of your screen. Now, without further ado, I will hand it over to our speakers to begin the discussion. Thank you.
So, thank you for the introduction, Michael. It certainly is a cold morning today, and I hope everyone's staying safe and warm. So hello again and welcome. Welcome to today's session on Serious Accidents Punishment Act. We are very excited to have this opportunity to discuss and to start this dialogue about the new industrial safety related law, which has been just enacted in January. Now, during the next 40 minutes or so, we hope to achieve two main objectives with this webinar. One is to demystify the law by providing a concise overview and summary of key issues concerning the Act. And two, to really steer you in the right direction so that you can begin to ask the right questions concerning health and safety practices within your organization, and to meaningfully engage in discussions with your internal stakeholders. Also, to begin the process of identifying any gaps and or opportunities with respect to your current internal systems in place, all to ensure health and safety of your workplaces, ultimately to comply with the law. Okay, well, we will begin by introducing key provisions of SAPA. What are serious accidents? Who are the responsible parties? What obligations are prescribed? And what liabilities are provided for in case of violation. We will then take some time to discuss some of the main issues we have identified. Lastly, we'll address some questions from the audience, starting with the FAQs we have prepared. So, as you may be aware, on January 8, 2021, Korea's National Assembly passed the Serious Accidents Punishment Act, also known as the SAPA. The Act will take effect in two phases. For businesses with 50 or more employees, the Act will come into force 1 year from the date of promulgation. The promulgation occurred this January 26, so it would be around January 27, 2022. For businesses with less than 50 but at least 5 employees, the Act will be effective starting January 27, 2024, which is 3 years from the date of promulgation. And for businesses with less than 5 employees, the law does not apply. To give you a little more context and background about the law, it would be helpful to briefly look at the legislative history. The lawmakers wanted to address growing concerns about numerous deaths related to industrial accidents in Korea, as well as to prevent public disasters which affect the lives of the general public. Some of the key issues that the enactment of SAPA hopes to address are environmental health and safety manager not having the requisite or adequate authority to effectively carry out their duties and obligations. As often, not too senior a person within the organization is tasked with managing and ensuring health and safety in the workplace. The recurrence of similar accidents that should have been prevented due to lack of accountability at the top of the organization or outsourcing of hazardous or dangerous work to third-party subcontractors, product defects harming consumers or serious accidents that involve and affect the general public. So by introducing severe punishment for failure to adequately establish and implement safety and health measures, especially holding the most senior person in the organization liable, who has the authority to influence health and safety measures, the legislative goal is to prevent serious accidents, whether industrial or public, and to protect workers and the general public by having organizations implement health and safety management systems aimed to protect not only their employees, but third-party workers as well. Now, if you look at the chart, I'm not sure whether you can actually make out the details, but this is to provide you a perspective in terms of the new number of fatalities from serious industrial accidents by country. And Korea ranks almost at the top of the list, one of the highest among OECD nations. And by industry type, the most number of industrial accident-related death occurred in the construction industry, followed by manufacturing industry. So, what types of serious accidents are subject to punishment under SAPA? There are two types of serious accidents under the Act. Serious industrial accident and serious public accident. But for purposes of today's webinar, we'd like to focus on the serious industrial accident, which we believe would be more relevant for our discussion today. So how is serious accident defined? Basically, any industrial accident as defined under OSHA, Occupational Safety and Health Act, that result in 1, 2, and 3. And what I mean by this is 1, at least 1 fatality, or 2, at least 2 injuries needing 6 months or more medical treatment, or 3, at least 3 persons contracting occupational illness, disease from the same cause, basically exposure to the same occupational hazard. The term serious accident is also defined under OSHA, but OSHA defines serious industrial accidents a little differently, but it is fairly similar except for specific threshold numbers. So with respect to serious public accidents, it is defined as defects. This is a very broad concept as well. Defects in design, manufacturing, installation, and maintenance of specific materials, products, public facilities, or public transportation resulting in 1 or more fatality, 2, 10 or more people getting injured requiring medical treatment of at least 2 months, 3, 10 or more patients requiring medical treatment for the same cause for at least 3 months. The lawmakers were actually thinking of the humidified sanitizer issue and they were very disastrous when they decided to include serious public accidents affecting the general public of the Act. So now, all important question, who is held responsible? A business owner or responsible management person, short RMP, who has de facto responsibility over business or workplace will be responsible under SAPA. The Act specifies that a business owner is someone who engages in his or her business with labor or services provided by others. This is basically a person who is a sole proprietor. Also, SAPA identifies responsible management personnel. This would be more relevant for most of you joining us today. As a party that can be held liable. There are 2 categories of RMP. One is someone who represents and are in charge of the overall business. The other is someone who is in charge of health and safety matters. So what duties do business owners and RMPs have? Well, Article 4 of the Act provides for 4 broad categories of duties and obligations related to ensuring health and safety. When is a duty with respect to safety and health triggered? Well, it is when the person has de facto control of overall management of business or the workplace. In addition to Article 4 that I just mentioned, Article 5 of the Act specifically places duties and obligations on business owner and RMPs with respect to third-party workers. There's a requirement that needs to be met to trigger the 4 main duties and obligations specified under Article 4 of SAPA. So even in cases of outsourcing to third parties through subcontracting or the dispatch outsourcing arrangements, the obligation to secure safety and health in the workplace will fall on the RMP only to the extent that he or she, in fact, has a responsibility to control, operate, or manage the relevant facilities or equipment or place. This, again, is a very broad concept. So now, what do these responsible parties need to do to comply with SAPA? Well, SAPA imposes 4 quite broadly worded obligations, but can be summarized as follows. With respect to health and safety measures, establishing, adopting, implementing, preventing, and managing. One has to establish safety and health management system, which includes people and capital resources, and take measures to implement such system. 2, if there is an accident, come up with a plan to prevent the recurrence and take measures to implement the plan. 3, if corrective orders are issued by a government entity, adopt appropriate measures to improve the safety and health management system. Lastly, take managerial measures necessary to comply with the obligations under health and safety laws. Although it's not certain, health and safety obligations are most likely those found in OSHA. Let me remind you that not all information is available at this time, such as what do we mean by to establish safety and health management system? What does it mean to take measures to perform obligations in compliance with safety and health laws and regulations? These specific requirements will be available in the coming months, and details regarding the requirements will be further elaborated in the enforcement decree, which will be promulgated this year. What type of criminal liabilities are provided? Why don't we ask my colleague Kyson, to my right, to explain to us what to expect. So Kyson, do you mind answering this question?
Okay. So sure, earlier, Sung mentioned about the serious industrial accidents resulting in 1, 2, and 3. So with respect to at least one fatality, SAPA provides for imprisonment of at least 1 year and /or a criminal penalty of up to 1 billion Korean won. Regarding 2 and 3, where the serious injury, illness, does not involve any death, SAPA imposes an imprisonment of up to 7 years or a criminal penalty of up to 100 billion Korean won. And for repeated violations within 5 years, the maximum penalty will be increased by 50%. In addition, for companies, SAPA now provides a joint liability in case a company has not exercised due care in maintaining its health and safety system. In case of an accident resulting in death, a criminal penalty of up to 5 billion Korean won will be imposed on the company unless it can show that due care in maintaining a health and safety system has been exercised. In the event where there is no fatality, a criminal fine of up to 1 billion Korean won may be imposed. Also, for willful misconduct or gross negligence, the business owner or the company may be exposed to punitive damages of up to 5 times the actual resulting damage. Now, as for administrative penalties, a business owner or RMPs, responsible management personnel, must attend a safety and health training class. And if the person without justification fails to attend the class, he or she will be subject to administrative fine of up to 50 million Korean won. The Ministry of Employment and Labor, the MOEL, may publicize the violation and the occurrence of the serious industrial accident on their website.
Thank you guys. So you may be wondering what the relationship between SAPA and OSHA is. So if you recall, Article 4, Item 4 of the duties and obligations refers to the performance of obligations under safety and health laws and regulations. We believe that safety and health laws, in this case, refers to OSHA. However, it seems unlikely that all 670 plus duties and obligations under OSHA would be equally applicable to duties and obligations under SAPA. Again, we'll need to see what's included in the enforcement decree to be promulgated this year. The next question may be, how does Serious Accident Punishment Act compare to Occupational Safety and Health Act? Now this time, let me ask my colleague to my left, Jay, do you mind explaining what the difference is?
Not at all. Thanks, Sung-min.
Thank you.
I think for now, and there's many question marks, as Sung-min has alluded to, but we have to think about OSHA, obviously, as the current statutory regime to set the requirements, the legal duties and such for workplace safety. And there will be an overlapping regime under SAPA that will define a certain elevated level of responsibilities, duties, and penalties, and so forth. And all these 5 E's, you'll notice, are basically synonyms, right? They all become enhanced, expanded, so on and so forth. But essentially, it means that the requirements on the business owner, on the manager of the site, are becoming elevated under the application of SAPA. And that was the intent behind the law. So that makes sense. So this applies to things like what the company needs to do to enhance or protect worker safety, where you have subcontractors, what you need to do to protect the safety of those workers, who will be subject to punishment. The scope is increasing under SAPA, as Sung-min already described, going beyond the EHS personnel and trying to reach. And I think the key word here is actual, right? We use that word actual at numerous points. Who has the actual authority and therefore had the duty or the obligation to exercise that authority to do all these things to better ensure and provide for worker safety. The punishments are going up, obviously, as Kyson alluded to, and you have punitive damages under SAPA, which did not exist under OSHA, and that can be a significant source of legal risk as well.
Thank you. Thanks, Jay. That was very clear. I like that 5 synonyms that you mentioned. They all mean the same thing, but you know, it's sort of elevated everything.
Always better to repeat things.
Yeah, expanded. So I appreciate that. So main issues, right? So what are the key issues under SAPA? Well, we believe that the issues can be summarized with 3 W's: who, what, and who. And let me explain what this means. Who will be held accountable for serious accidents? In this context, we've talked about responsible management personnel. What must be done to prevent safety and health risks? Remember the 4 duties and obligations of health and safety measures. To whom is duty owed? In addition to the workers in the traditional sense of the word as used in OSHA, there's a responsibility now for workers employed by third parties as well, which is triggered if there's an actual de facto responsibility for the workplace, facilities, or equipment. So, who is responsible? Management personnel. You're asking. Well, businesses should identify who may be responsible for the obligation and be ultimately found liable under SAPA. What exactly do we mean by a responsible management personnel? Well, it's a person who represents a business and has the authority and responsibility to oversee the entire business. If you're familiar with how companies are organized in Korea, this person is usually the representative director, the CEO. For most multinational companies in Korea, these people may be general managers, country manager, or managing director. Also, for those who have the duty to manage health and safety matters, who have comparable authority as the person who has the responsibility to represent and generally and comprehensively manage the business, are considered RMP. What this means is that someone in charge of EHS must have the same or similar quantum of authority and responsibility as the representative director to be considered an RMP. So it's important for businesses to identify who is a responsible management personnel under SAPA by closely reviewing their existing company rules and regulations, organizational hierarchy and allocation of authority, in particular over occupational safety and health matters. And once identified, businesses should explore ways to ensure appropriate risk management for such a person. The key concepts such as responsible management personnel and de facto control, operation and management are not clearly defined. And while this vagueness will be addressed through the enforcement decree and the relevant government agencies' interpretation to a certain extent, it is expected to take some time to establish sufficient precedents for clear guidance. Given the broad definition of responsible management personnel, it is reasonably expected that there would be some disputes as to who should be the RMP. If the RMP is a foreign national, perhaps there's a risk of exit ban as well. With respect to what needs to be done, the Act will become effective in 2022 and 2024. So for businesses employ at least 50 employees, as I mentioned, it's January 2022. So we have approximately 12 months of grace period. And what do we need to do until then? Well, we need to build enterprise level safety and health system that is based on cooperation at all levels within the organization, such that safety and health are not delegated to staff function on site. How do we go about doing this? Well, review and analyze scope of responsibility and authority under current internal regulations and organizational structure. Review options of enhancing or delegating duties and responsibilities or exercising oversight to prevent non-compliance with applicable safety and health laws. Analyze past cases and prepare remediation measures. Identify root causes and categorize accidents by type, such as machine-related or human-related. Establish system for preparing measures to prevent recurring accidents and to facilitate smooth implementation on site. And also, involve safety and health teams as early as possible, perhaps from the time of procurement of facilities and equipment. Come up with a safety and health plan by considering the various attributes and size of the workplace. So develop and establish response measures in light of existing safety and health laws. Also, benchmark others for best practice, review past occupational injuries, accidents, and come up with a realistic, achievable target. Also, have sufficient people resources and budget. Conduct mock audits to identify risk and opportunities. Now, you need to remember that safety inspection should include facilities and equipment and not just the workplace. Also, educate and train worker safety and health, and consider what type of improvement can be made to facilities, including automation of dangerous facilities, if possible. Also, because you're dealing with people in the system, consider rewarding best practices. Again, conduct internal campaigns to increase the awareness regarding safety and health in the workplace. It's imperative that you budget adequately for this.
So if I could jump in for 1 minute at this point, Sungmin. So it's interesting because I think most all of our AMCHAM members are probably doing all of these things already. And these are things that, you know, we should all do, that we should pay attention to, right? And it's an interesting aspect of SAPA that definite risks and red flags that we all need to be cautious about, watch out for, which is why we're doing this webinar. But I think it also defines a moment of opportunity of sorts as well. It's a chance to review your current practices. And again, I think most all of our members are doing all this on a continuous basis already, but a good checkpoint to make sure that we are implementing what we set out to do, and to look at where there are any gaps that we should fill in. So I think if we use this moment of opportunity to upgrade our practices, it's obviously something that all companies want to do anyway. We all want to do the right thing. We all want to provide the safest possible environment for our workers. So it can be also considered in that, with that viewpoint as well.
Absolutely, Jay. So that's a great point. So we talk about identifying risks, root causes, issues or gaps, but it's really finding that opportunity to really ensure and commit to, again, we commit to that safety, overall safety of the workplace, the people, and what have you. So this is a great, again, opportunity for you to really look into your organization and the existing practices.
Right, and putting back on my lawyer hat, in case this does become an issue or these issues do arise, all this stuff is good defense evidence as well, right?
Of course, and we'll address that issue as well, and Kyson will be able to provide you with some insight later on.
With this enactment of the law, there was some kind of criticism that this was too proactive and progressive.
Right.
But actually, the momentum was intended by the National Assembly to establish, to boost the whole community and the Korean society to have more concern and interest in this topic.
It's really raising awareness, and we did mention that, and also awareness in the public. Definitely, they have awareness, but internally, also you need to engage your workforce and the people, the managers, and that's why internal campaign is something that we would also recommend. But anyways, moving on to whom is the duty owed? So it's to your own workers, obviously, and the workers of third parties. We mentioned that. But with respect to third parties, only to the extent that RMPs have actual de facto responsibility to control, operate, and manage, again, the facilities, equipment, or the workplace. So OSHA's concept is more about workplace. SAPA sort of expanded that concept, and now it includes facilities and equipment as well. So you may be asking the question, what does worker mean? So how is it defined? Well, it's basically laborer, someone in an employment relationship That's the traditional definition. But in addition, someone who provides labor service to carry out your business. It's a very broad concept, irrespective of whether the labor service is provided in connection with subcontracting, delegation, or outsourcing arrangements. So, to summarize, how to establish, adopt, implement, and manage safety and health plan and system. For a plan to be effective, we need to have something that is specific, measurable, attainable, relevant, and time-bound. We all know this. And what do we mean by this? Well, identify and assess current internal system in place and risk factors, such as past industrial accidents, gaps, shortfalls, opportunities within the policy system. Analyze and categorize risk factors identified. Select and implement various control measures in response to each risk factor identified. And again, this is an ongoing effort. Such incorporate additional measures and continuously improve existing health and safety measures based on realistic KPIs. So we have covered many things today, such as legislative intent, goal of SAPA, the responsible parties, health and safety obligations, potential liability, criminal, civil, administrative, and some of the steps that you can take now during this grace period. So we would like you to go back and look at your organization and business and focus on the specific risk targets relevant to your business, such as what types of work carry the highest risk exposure to workers, what accidents occurred most frequently in the past, and what were the root causes. What types of serious accidents occurred in the same industry, and what were the root causes as well. So with that, we're basically done with the presentation piece, and we hope it was informative. It's a lot to absorb. We understand that in 30, 40 minutes, and the concept we discussed may not be too clear and somewhat complicated. So to clarify the points that we've already made, we have prepared a frequently asked question based on many questions that we received beforehand. So for this FAQ, we have pre-selected some questions that can be largely divided into 4 main types, categories. Responsibility, applicability, de facto control, and liability. My colleagues here sitting by my side, Kyson and Jay, will help me address these concerns. So with that, ultimately, who should be held liable? Representative director, health and safety manager, or both? What would take for non-representative director to be considered a health and safety manager who can be held liable as RMT under the SAPA? And I think Kyson could help us answer this question.
Well, I'm sure this would be one of the most frequently asked and debated questions for some time. And it would be interesting to see how things will play out. To begin with, let me first summarize briefly what Sungmin already explained regarding this issue. Responsible management personnel, RMP, bears the obligations to ensure health and safety to prevent serious accidents, and they are the ones subject to criminal liability if such accidents occur due to violation of the health and safety obligations. But based on the language of the SAPA, the term RMP refers to either representative director or health and safety manager, but it doesn't indicate which one of them would be punished solely or primarily for non-compliance with SAPA obligations. And that's why we would expect some controversy over who bears the liability in the end. But it seems natural to argue that only the health and safety manager should be subject to liability, because he or she may be the one who has the direct duty to oversee health and safety matters instead of a representative director. And therefore, the RD should not be held liable on their account. However, considering the fact that SAPA was enacted to address this criticism of top management shifting responsibility and getting away with non-compliance, we would anticipate that the investigative authorities may force the target CEOs and the RDs rather than HS managers during the investigation. It's also more likely that SAPA complaints will be filed by the alleged victims against the top management, which should then lead to their investigation automatically based on the complaint filed. And if the RD is a foreigner residing in Korea, there is a high likelihood that an exit ban may be imposed at initial stages of the investigation. So the CEOs and RDs would remain exposed to SAPA complaints and investigations, at least for some time, until we have a sufficient number of SAPA cases to establish precedents, which may decide otherwise later on. On the other hand, we cannot also rule out the possibility of the authorities going after both the RD and the HS manager in cases where both of them knew that accidents could happen because of insufficient health and safety measures. But once again, it still remains to be seen how the practice will be established and developed over time. Lastly, as Sung-min highlighted, it's important to remember that for someone to bear the responsibility and liability as an HS manager under the SAPA, he or she needs to have the authority and responsibility which are comparable to those of a representative director. So for example, having the authority over personnel, budget, and organizational structure regarding health and safety matters would allow a higher chance of being recognized as RMP under the SAPA.
So thanks, Kyson, for that. And not to scare anyone, you talk about exit ban.
Sure.
How common is this? Is it at the onset if you're working with, or if you're actually targeting a foreign CEO or country manager or representative director? Is that exit ban imposed?
Well, it is being used increasingly by the authorities at the beginning of the investigation against the foreign top management. So it is a travel ban. So once the exit ban is imposed, even the top management cannot go out of Korea to do business, to do vacation. So there's a big and serious restriction on the.
Could we seek some sort of exception or exemption from the exit ban? So can we guarantee something that they'll come back, or?
Yes, sometimes and then the company provides a safety guarantee to the authorities, but it works as a temporary lifting, not the permanent lifting or the cancellation of the exit ban itself.
Okay, 4 questions. So, actually, we were, yes. And can we see the questions again? Thank you.
It looks like we had some questions from the audience, which is always much appreciated. The first one we see is, can the RMP be a regional manager or director located outside of Korea? Which I think anticipates at least one of the FAQ presentation slides.
Oh, right, and we that is the case. And
should I take?
Sure, I mean, thanks for volunteering that.
Yeah, so the RMP, it can be somebody located outside of Korea, theoretically, anyway. It's a bit strange, right? Because this is a Korean law, you're talking about a Korean workplace, so it's not very intuitive. But we can think of a scenario where actual authority over the Korean worksite is exercised from outside of Korea, Tokyo, Singapore, wherever, in today's world, especially with all the remote working going on, this is even more of a possibility going forward, it seems like. This does raise tough issues, I think, in terms of the actual ability of the, let's say, the prosecutors to investigate, get the person into Korea for questioning. Seems a little unlikely that would happen. We're physically coming into Korea at that point, but the short answer to this is theoretical yes.
Right, so long as they have actual control over the operation and management of health and safety matters as well as the workplace and overall business. So it is a broad concept. We really need to look at the case presence, which we have none, and we'll see how things will unfold. But for the time being, I think what you've explained sort of captures the current state and expectation. Another question from the floor. Let's see, why don't we take this one first? If an accident occurs, notwithstanding all reasonable efforts have been made to prevent, will liability arise? And Kyson, I think maybe this is more something like strict liability or no fault. Can you?
So this is not the strict liability, not the strict no fault liability, but it can be considered as a quasi strict liability provision. So we have a provision in this law that in case a company can show that they have exercised due care and full oversight, and full supervision on the workplace, the company or even the top management can be free from this obligation, from this violation. But it's not easy to establish from the defendant, from the accuser side, to show to the authorities that they have exercised full safety measures. So ultimately, in the end, at the end of the investigation, the company and the top management can be cleared of this alleged the suspicion, but it takes some time and it takes some efforts to establish, to show that they have exercised due care. So that's the problem, that in practice, the burden of proof should be on the shoulders of the prosecutors. Right. In practice,
So the presumption is you guys done something wrong and you violated and you didn't follow the necessary procedures and process.
The answer to this question has to be no. The way the law is drafted is that if all reasonable efforts were actually taken, then there should not be any liability. But I think the question, or the malleable term, is reasonable, right? Because that's always in the eye of the beholder. And in retrospect, something that seemed fine at the time can always look worse. So that's another aspect of investigations into these types of issues that we see on a fairly common basis.
Okay, and there's another question. What is the best way to ensure we have the records to show we have taken adequate and all reasonable measures to prevent accidents? Again, welcome to chime in, but the records alone will not be sufficient. But with the amendment of recent amendment, OSHA representative directors have the responsibility to provide a written plan, a report of safety and health measures, and report that to the board of directors. Again, as we discussed, written records are great. That should be, we need to have a system in place, and for us to have that, we'll need certain records, and we talked about mock audits and training, those things. But in reality, if an accident were to occur in the workplace, then it's really, you're looking at whether the system is actually operating appropriately. So we don't believe that you can just rely on records alone to support your case. And from a prosecution perspective, you will look at, you interview people, you actually visit the site and see whether record alone will not be.
Even based on my experience as a defense lawyer, when we get such kind of records from the client company, we feel relieved that we have something to show to the prosecutor's office. And then this is the basis on which we can start our advocacy for our client towards the prosecutor's office.
I agree with all of that. The only thing I would add is that in dealing with these types of issues, the EHS function of companies tend to not have the best, in my view, in my experience, documentation practices, and it can be beefed up. So I think it does make sense to take a look at what your EHS team or function is doing, and look at the documentation that's being generated. So there are a number of safety and accident prevention plans that are required under OSHA, for example. And of course, all those should exist. But in addition to that, documentation of identifying safety issues, discussing the issues, coming up with a remedial plan, and then how the company implemented it, all that stuff can be potentially useful. And it's probably part of just good practice that should be implemented at any work site that raises or involves worker safety issues.
So ultimately, with the enactment of with the enforcement decree, we'll find out the actual details, the missing piece that when we talked about the 4 main duties with respect to obligation, or what we mean by having a health and safety system in place and things like that, and what duties exactly need to be fulfilled and addressed within the system. And so, that's a good point and good question. So there's another question, is regular training required to show you have taken reasonable steps to prevent accidents, and how often should such training take place? The question is whether regular training is required and the frequency, and we did talk about training with respect to as part of the health and managing system and implementing that in your workplace. So
I think the short answer is more the better, right? Is it required under SAPA? No, SAPA doesn't say you have to do this, but by the terms of the law, it's clear that it is a good idea to do this. And OSHA separately sets out training requirements, so all that should be complied with, but there can be no drawback from more frequent training sessions conducted for workers on safety. So maybe not required, but absolutely, I would say almost required. And that's part of the reasonable efforts, to show the reasonable efforts that we have taken to prevent accidents and provide for worker safety. How often should such training take place? To be practical, I think, depends on the type of training too. If it's something that's not overly burdensome, I would think even monthly sessions would be a good idea. For the more expansive ones, quarterly. So there, I think we can exercise some common sense in designing that.
And I'm sure there are many ways of conducting these training as well. So the advice is really look at the organization as is, see the opportunities you have, and you may already have sufficient training materials and methods in place, just that it may not be as frequent as you would like to be, or people are not necessarily attending those trainings. But I was just wondering, Kyson, so with having these reasonable training and preventive measures and all that, how would that relate to, say, if you're held liable for a violation? Now, you said it's at least 1 year and above. Would that help out in terms of lowering the...
I think this training will be helpful in making the company free from the punishment, and also it can work as a mitigating factor. But it isn't an absolute rule that once you train, then you will be free.
Right.
We cannot say like that. But this will be the one factor to contribute to defend the company and the RMPs against some investigations with the suspicion.
I think this also somewhat links back to the documentation question as well. I would say keep record of the training, right? The slide decks used, the Q&As and all that. Very often I've seen, just speaking of my experience, just dates and we didn't hold this training. So it's just literally dates with the type of training. And it's good that we have a record of that, but it's not as rigorous documentation as we would like to
say actual attendees.
Yeah, attendees, sure.
Yeah, and
maybe not up to the level of signature, but yeah, I mean, if that's not too burdensome, that'd be good too.
Right. Okay. So yeah, it seems like documentation alone, it's not gonna. But yes, it would definitely help.
Nice to
mitigate.
have.
Nice to have. Yeah. We've already talked about this.
1 and 2, I think.
Yeah, I think we've, and also, what does it mean by having actual de facto control? We talked about the liability issue.
We had some good questions. Anticipating us.
We had some excellent questions. So not to scare people, but I know I'm not really fixated on this, but in terms of liability, I think people are, just because a lot of our members are senior members of the organization. As a prosecutor, what type of liability are we? Can you give us a little more insight?
Yeah. We don't have any precedents, right?
Right.
Which apply them on the SAPA. But even as a former prosecutor, so it's hard to predict an expected level of penalties, especially from an early stage, because investigation is a living thing and it's difficult to foresee how things will twist and turn at each and every stage of the investigation. But one thing is clear, as Hong-Min already mentioned, SAPA criminal penalties are very severe. For example, in the event of a fatal accident, although a fine could also be an option, but the minimum baseline for imprisonment is at least 1 year, which means in theory, the maximum could go up to as much as 30 years. So considering the purpose of SAPA's enactment and also judging from the precedence of the OSHA cases, it seems more likely that a sentence of imprisonment rather than a fine would be imposed in case of SAPA accidents. And depending on the scope and the seriousness of the SAPA violation and the accident involved, the investigation authorities may take much more aggressive actions, such as arresting responsible managers so that they can remain detained throughout the trial as well. So of course, mitigating factors could help to reduce such risks. And one of the most effective means of reducing the risk is to enter into a compensation settlement with the victims or their families. However, it is doubtful whether such settlement would be realistic or viable under the SAPA framework, as SAPA also makes it mandatory for the company to pay punitive damages, which is the exception in the Korean legal system, to victims anyways. However, the most important factor, among others, will be the degree and the level of compliance with the SAPA obligations, at the time of the accident. So let me emphasize again how crucial it would be to prepare as much as possible in advance in that regard.
Thank you, Kyson. That was good. So I think we have maybe one more question. We can entertain this. What kind of protection measure can be considered for workplace only with white-collar workers? I think we mean office workers. Offices usually already very safe, right? So SAPA does apply to office worker only workplace, and it doesn't really distinguish between whether it's a workplace with obviously dangerous and hazardous equipment facility. But as an RNP, there is obligation to ensure health and safety in the workplace, so long as you have control over it. So what would be considered necessary protection in the office where it is tend to be usually safe? It's rare that you run into.
Yeah, I think making sure that you don't have any overt defects in the office environment, like these huge panes of glass behind us, make sure that they're properly installed and so forth. I think the biggest risk actually in this context comes from in the occupational injury context is overwork for white collar workers, and you do see cases of workplace injury, occupational injury claims being made due to an oppressive work environment in terms of the workload. Now, as to the intersection between SAPA and those types of claims, I think we'll just have to see, but it seems a bit remote. So
right, but I think for this, let me remind you that you are also liable for third-party workplace as well. So let's say, for instance, for banks, if you're relying on call centers, and if you are exercising somewhat of a control management over the workplace or the equipment of the facilities, then in that instance, you want to make sure that the third-party workers are also, as well as within that workplace, there's a system to ensure health and safety. So just because you're outsourcing this particular work doesn't necessarily mean that you're off the hook. Okay.
yeah, accidents can happen anywhere.
Right. Right. Okay. So I think we can spend the entire day just entertaining more questions, and I think it's great that we can actually communicate with you today, although we can't see you in person. But us at KNC, we're here to help you and assist you and guide you. And please feel free to reach out to any one of us regarding SAPA. Thank you so much for your time. We hope to be able to sort of have additional webinars like this to continue the dialogue that we started today. So thank you so much for your precious time. And you guys have any?
Thanks, everyone. Really appreciate your time.
Okay.
Thanks for the opportunity.
Thank you.